now we're going to talk a little bit about estate planning. So what is estate planning? Well, the foundations, when it comes to it, are wills and lasting power of attorney. So why would you have a will in place? A will basically makes sure that you can appoint the right people to be in charge of sorting out your affairs. They are called executors. One of the massive parts for people with children below 18 is appointing guardians. It's really important you make the right decision of who would be best fit to look after them. And that's a massively important part of writing a will if you have children below 18. The other part is obviously making sure that your assets are going to go to the right people. Of course, there is more you can include, but these are some of the really important decisions to consider when making a will. Then you have lasting power of attorney. These documents are incredibly powerful tools as they give you the right to appoint people to make decisions on your behalf if you can't anymore through lack of capacity. The only people you're able to make decisions for legally without having either a lasting power of attorney or a deputyship in place is a minor child that you have parental responsibility for or are a legal guardian of. People presume that if someone's married or in a civil partnership, you can make these decisions for the other person. That isn't actually correct. Unfortunately, if you're in these situations, it can cause a lot of stress because you don't have an automatic right to make a decision for the other person. So having these documents in place is a really powerful tool to make sure that the right people are in charge of making decisions for you. And also they can act as soon as they need to if anything were to happen. So here we have a case study. We've got Zara and Alex, married, young children, obviously assets together, some assets that are singular. They don't have a will in place and they don't have any power of attorney. So unfortunately, in this case study, Alex suffers a sudden illness and becomes unable to manage his affairs. There's no power of attorney in place, so Zara cannot have any say in terms of his treatment. It also then causes issues in terms of their finances. They have a joint bank account. Now, you would presume, because both names are on there, that the other person could still kind of act as they need to. In fact, this can cause issues, and in this case study, you can see Zara's access to their joint account is now only allowing her limited withdrawals, which can cause massive disruption in someone's life. Alex's condition worsens and Zara worries what this means for their assets. She's already obviously had difficulties up till that point. Because Alex has now lost capacity, he unfortunately is unable to instruct a will. Sadly, Alex passes away without a will or having lasting power of attorney in place whilst he was alive. So joint assets pass outside of the scope, so they automatically would pass over to the other person. But other assets could now pass to the children. On the next slide, we'll talk about the intestacy rules, so you can see how that would work in real life. So here we have the intestacy rules. In the case of Zara and Alex, you can see they do have children. They are married. So what this means is the spouse receives up to the value of $322,000, the property home, so the marital home. Anything after that is then split between the children and the spouse. So the issue that you have here is, in the first instance, they wanted everything to go to each other. Potentially, if someone's estate value is big enough, the children are going to inherit a lot sooner than they should. This can cause a lot of difficulties ongoing. The surviving spouse still needs to continue their lifestyle, provide for the children. If the children are inheriting and they're still minors, that can cause huge problems for the future. So just by having a will in place, even if it's something super basic, it is going to make sure that your assets are going to go to the right people. By having the lasting power of attorney in place, you're making sure the right people can make decisions for you should anything happen. So life can continue as normal, or as normal as it could be, with that document in place. So here we've got a different kind of case study. We've got John and Jane, married. They do have a will in place. They've got 2 adult children. John had a very large death in service. So as we know, death in service actually are exempt in terms of inheritance tax when they're paid out for that person. However, there are other issues that could occur. So we'll go through them now. John passes away, and with his death in service, it's passed over as a tax-free lump sum to Jane, which it now sits inside her estate. Jane gets remarried to Jeff. Unfortunately, this ends in divorce. there is potential there that in the divorce proceedings, she's going to lose 50% of her estate. So 50% of that death in service is now sat with Jeff. Then we've got problem 2. James passed away, still married to Jeff. So what that means is sideways disinheritance. So Jeff potentially could end up with the full 1 million. Problem 3, James passed away. The 1 million is now subjected to inheritance tax. Inheritance tax is 40% of anything above someone's allowance. So in this case study, you can see that 40% is a £400,000 loss of that initial death in service, which is a huge amount of money. Problem 4 follows on from problem 3. So the asset is now sat inside Jack and Jill's estate. Jill passes away, and then there's potentially a further 40% paid for inheritance tax. So then the grandchildren end up with 180,000 from the initial 1 million because there's been 2 lots of inheritance tax paid on that death in service. Problem 6, death of a grandchild. As you can see, there's 4 lots of inheritance tax that potentially had to be paid here. That's a huge loss through 3 generations. The great-grandchildren end up with 108,000, whereas the death in service initially started at 1 million. As you can see here, there's a huge potential loss, not just from inheritance tax, but also from leaving assets to bloodline. What can we do to protect these things? Making sure that your affairs are in order is a really, really great way to make sure that your assets are protected for future generations, and also making sure there's tax efficiency in terms of inheritance tax. So what are your options? Number 1, spending it. I come across so many people that are trying to protect assets for the future generations that they forget about themselves. Spending the money and enjoying it on yourselves, it should be a number 1 priority. And it also reduces the estate value. So it's a win-win. Gifting to children, which you can do outright, or if you wanted to be really savvy, gifting into trust to have that extra protection, which is something that we can look at. Some people take out a whole of life policy to cover what their liability is, or cover as much of it as they can. This can help with the inheritance tax. Trusts are a really great way to protect assets against potential things like a remarriage, divorce, generational inheritance tax, just making sure that your assets are going to go to the right people and that your wishes are followed through, even when you're not here.